So it's a great pleasure to welcome today Massimiliano Kadar. So Massimiliano is the head of the ECN unit, since a few months now, I think. And he has been involved, however, in the drafting of the guidelines on Article 102 with Inge Burnett, who unfortunately could not make it today because she has to prepare for the transition of a new designated commissioner. But we're very, very excited and happy to have Massimiliano with us because having been involved also in my previous capacity in discussions about Article 102, I know that Massimiliano and Max, as we call him, has quite interesting ideas about Article 102. He's extremely knowledgeable about the case law, and obviously we see that care taken in the guidelines to fit with the case law. So what we try to organize a session as following. So I will ask Max to share a few words, introductory words about Article 102 guidelines, in particular eventually addressing some of the issues that were raised in the previous panel, and then we're going to follow up with a discussion and open that to the floor for questions, all right? So, Max, the floor is yours. Go ahead.
I'm very grateful to Yanis for the kind invitation, and that, as usual, my views are my personal views and do not necessarily represent those of the European Commission or DG Comp. So the idea indeed is to kick off with a short presentation. A lot of this will not be new to you, given that all of you understand and read in the details the draft guidelines, but still I thought it would be helpful to have a little bit of an overview of the content of the document, and as anticipated by Yanis, to the extent possible, I'll try already to address some of the points that have been mentioned before. I should say, before I go into the details on those specific points, that of course it has been mentioned in the panel, this is just a draft. So by definition, these are provisional views of the Commission, and potentially they may change in the future as we move towards the final document. That being said, I have my personal views on what we have written in the document, and so I'll be happy to share them with you all. In terms of background, you all know that Article 102 is a bit atypical in terms of comparison with other EU competition law instruments, in the sense that there is no guidelines currently in Article 102. We have the guidance paper issued in 2008 or 2009, and in that the Commission has amended that guidance paper last year, on the 27th of March. It was through a number of surgical amendments, which we considered a short-term initiative, and the purpose of that initiative was simply to bring that document in line with the Commission current approach. That being said, there was a lot in that document that did not necessarily represent the current state of the law, and because of that, the Commission has decided to launch at the same time what we call a long-term initiative, so to have guidelines on exclusionary abuses of dominance. That was done through what we call a call for evidence, which was essentially a document inviting stakeholders to provide comments. In parallel, at the time, we had published a staff-level policy brief, which was providing more details on the background of the initiative and was promoting what we call the workable, effects-based approach to Article 102, and I'm going to say a few words on that in a second. So we have received since then 48 responses to call for evidence. One important element is that stakeholders by and large welcomed the initiative and have highlighted that this initiative has the potential to bring additional clarity and legal certainty in the application of Article 102 to exclusionary context. So there was certainly very positive initial feedback. And of course, as you all know, on the 1st of August this year, we have launched a public consultation on the draft text of the guidelines. There's three objectives in these initiatives. They've been already mentioned before. The first one is to systematize the rich body of case law of the EU courts on exclusionary abuses of dominance. We know that there are inherent tensions between different judgments. Some would say even contradictions between different judgments. The example of or and was mentioned before. So it is clearly the case that one of the purposes of this initiative is to try to provide the Commission's interpretation on how to address these tensions. Now, this will mean almost by definition that we will have to make a choice in terms of how to interpret the law, and of course that choice is guided by what we think that is the correct way to interpret this, but it is by definition unavoidable that we would end up having to give more weight to one or another judgment, and of course we can discuss on what is the right way to do it, but I think we shouldn't be surprised if there are some parts of the guidelines that depart, at least in part, from some specific language in some specific judgments. Second important objective is that of providing operational guidance to dominant firms as a means to facilitate self-assessment and of course to foster compliance. The more compliance there is, the better it is for us, because we can dedicate our resources to the cases that really hurt consumers, and that of course doesn't only go to the benefits of the Commission resources but also to the benefit of potential victims of abuses and EU businesses and consumers at large. And the third point, of course, is that of drawing lessons from the Commission's experience and from the EU Court's case law to promote, again, what we call a workable effects-based approach to Article 102. What we mean by that, we mean an approach that is both, on the one hand, firmly grounded in economic thinking, while at the same time it is also conducive to a robust and effective enforcement of Article 102. And I wanted to take the opportunity here to thank all the colleagues from the Commission, both from the legal service and from the chief economist team who have been involved in this exercise. In terms of structure, I'll be very brief here. We have a first introduction section which contains some important principles, for example, on the notion of exclusionary effects and consumer welfare. A section on dominance, where we assess both single and collective dominance. Section 3 on the general principle, the two-pronged test that we have highlighted. There has been some criticism expressed before about the fact that there could be a way to interpret the case law of the courts as suggesting that in fact there is no such a thing as a two-pronged test, that one would either have to show that the conduct departs from competition on the merits or that it is capable of producing exclusionary effects. We have not followed this approach because in light of the case law we think that it is very difficult to go that way. In particular, in light of the latest Google shopping judgment, Grand Chamber judgment, we find it very difficult to argue that these two are not cumulative. But that being said, this is the view of the Commission in the draft, and of course we're very happy to listen to other views. I'm going to have a couple of thoughts on each of these 2 points, or each of these 2 limbs of the test, starting from the next slide, so you'll see in a second. Section 4 is about specific categories of conduct. We have divided between conducts that are subject to a specific legal test and conducts that are not subject to a specific legal test, where the general test applies, but where nonetheless we felt it would have been useful to underline how this general legal test has to be applied. And of course, last but not least, a section on objective justifications. In the meantime, I'll start talking because I think I know what's next. Starting from the first of the 2 legs on the general test, the notion of departure from competition on the merits. Of course, there's been a lot of discussion about this notion in recent years. Some say that the notion of competition on the merits is unclear, and some say that there would be a need to have more guidance on how to apply this notion. Of course, we are sympathetic to all of this. We hear these calls, but on the other hand, we thought, as I mentioned, that given that this notion is central to recent case law in particular, we thought that there was really a need to provide guidance on our interpretation of the notion of competition on the merits. So how have we tried to operationalize this notion? Essentially to try to put in practice what is our view of this test. And we have highlighted 3 separate circumstances, 3 scenarios. The first scenario is when it comes to conduct that we call naked restriction, so conduct that has no economic interest other than to exclude. Well, that type of conduct always departs from competition on the merits. Second scenario is situations where we are dealing with conducts where a specific legal test applies. For example, predation, margin squeeze of exclusive dealing. In these cases, the notion of competition on the merits, and in particular the fact that the conduct departs from competition on the merits, is already incorporated in the relevant legal test. So again, nothing more to show in terms of proving that the conduct departs from competition on the merits. And third, everything else. We have highlighted a list of elements in paragraph 55 of the draft guidelines that can be relevant for the analysis. For example, whether the conduct consists of deceit or whether the conduct constitutes a breach of other areas of law that affect competitive parameters. And as part of this list of criteria, of course, there is also the fact that the conduct may lead to the exclusion of hypothetical as efficient competitors. So we have taken the position that if that is shown, for example, by means of a price-cost test, that is a way to show that the conduct departs from competition on the merits. Moving on to the second leg of the assessment, the general legal test, the capability to produce exclusionary effects. First of all, we have made clear that there is a broad meaning of exclusion, or full-fledged exclusion, marginalization of competitors, constraints on growth, increase in barrier to entry, and so on and so forth. All of this can be caught by Article 1 and 2. In terms of causality and attributability, we have stated clearly that from a conceptual point of view, it is necessary to compare the scenario with the conduct with the scenario without the conduct. At the same time, this comparison doesn't have to be done by looking at all possible scenarios, and it can also be implicit in the analysis. For example, if you were to look at market share evolution before and after the conduct, that is effectively an implicit counterfactual analysis. The third point is something that has caused quite a bit of discussion, and we've seen it in the previous panel, which is our interpretation of the case law as regards the modulation in the burden and standard of proof. Here at paragraph 60, we have essentially identified, in light of the case law, three different scenarios. The first is the baseline scenario, let's call it like this. For example, in the case of self-preferencing or in the case of refusal to supply, in these cases we have to show that the conduct is capable to produce exclusionary effects. The second scenario, paragraph 60b, is the scenario of conducts with a high potential of exclusion, which are subject to what we call a soft presumption. It is still a presumption in the sense that, at least theoretically, the Commission doesn't have to show anything, but this presumption can be rebutted. We have seen in the case law that effectively it has been rebutted, and we have lost cases where it has been rebutted, and therefore it is clear that if there is evidence to the contrary, we have to engage with this evidence. And third, conduct which we have defined as naked restriction, namely conduct where there is no interest other than to exclude. In these cases, they are subject to a hard presumption in the sense that it is still a presumption, it is still possible in theory to rebut it, but we find it as extremely unlikely that that would happen. So we have tried to put together these slides just to give an idea and try to systematize what I've just mentioned in a little bit of a more perhaps a bit of a clear way. As we mentioned, naked restrictions, no, it does not amount to competition on the merits, subject to a hard presumption. Conduct with a specific legal test, no, it does not have to be shown that the conduct departs from competition on the merits because that is already incorporated in the legal test. And then one has to distinguish between conduct for which there is a soft presumption and conduct for which there is no soft presumption. And last but not least, conduct where there is no specific legal test. These are only three examples that we deal with in the draft guidelines, but of course this box applies to any other type of conduct. So one would have to show that the conduct departs from competition on the merits and would have to show that it is capable to result in exclusionary effects. And just to address one of the comments that was mentioned before, of course it was stated that the guidelines do not seem to be future-proof, that there is no reference to novel type of anti-competitive behavior. I'm very sympathetic to this type of use. At the same time, we shouldn't disregard the fact that this is the first time that the Commission puts in documents the legal framework, at least the legal framework to show that a conduct can lead to an abuse of dominance. In other words, this is the first time that we put forward a general framework for analysis of abuses, and that general framework, of course, applies to any type of behavior. And that is, from my personal point of view, value in itself, because that's going to be helpful for the Commission, for national competition authorities, and for national judges to try and understand how to assess novel conduct and to which extent that novel conduct constitutes an abuse of dominance. On objective justification, I'll be very brief here. This section is nonetheless important, even if short, because it highlights the two types of objective justifications that can be brought forward by a dominant firm. First of all, the so-called objective necessity defense, where a dominant firm has to show that the conduct is both necessary and proportionate to pursue a given aim, and second, the efficiency defense, where essentially we codify the Potsdam 1 case law. In both cases, the burden of proof is, of course, on the dominant undertakings, and in both cases, if the conduct is subject to presumption, well, that would have to be taken into account for the purposes of the balancing exercise. I'm concluding on the next steps. The conclusion will run until 31st of October. This year, we're very much looking forward to receiving written comments from all categories of stakeholders, and I will underline from all categories of stakeholders, and not only from the usual suspects, I would say. We are also envisaging to organize a stakeholder workshop first quarter of next year. We're going to be publishing the details hopefully soon. And if all goes well, that will lead us to adopt the final guidelines in the course of 2025. Of course, one important element that I didn't mention so far in my presentation is what to make out of the 3 judgments that were rendered by the court on Article 1 and 2 in the last couple of weeks. But I'll be happy to say a few words on that, Yanis, if you think it's useful.
I definitely think it's very useful, so thank you very much, Max. Maybe you can join me here, we can start a discussion.
Pleasure.
And then open up for any discussion and questions from the floor. I hope you can hear me. I don't need to hold the mic. Is that okay? It's quite interesting. You started by saying that we are trying to put forward a workable effects-based approach. So we move from an effects-based approach to a workable effects-based approach. Is it the same kind of leap that we had in economics with John Morris Clark, moving from perfect competition to workable competition, which basically somehow raised the question, but what do we mean by workable? And workable can be something that can obviously, relate to specific circumstances. So my question is, what is the difference actually, between the effects-based approach and the workable effects-based approach? If you can just say 2 words. Yeah.
Thanks a lot for the question, Yanis. I wouldn't overemphasize the shift from one to the other, because I don't think there is any shift.
All right.
I would rather say that in the past 15 years of enforcement, we have learned that there can be some pitfalls in the effects-based approach if one brings it to the extreme. And we want to make sure that we avoid those pitfalls when applying an effects-based approach. So it is not a departure from previous practice. It is rather a way to codify the case law in such a way that is conducive to an effect-based approach that is workable and that takes into account the fact that sometimes there can be the temptation to go a little bit too far in terms of evidentiary burden. And we want to make clear that the kind of approach, the effective approach that we want to promote is one which promotes a robust and timely, I should say, enforcement of Article 1 and 2.
So the question I have also by listening to the previous panel is what we mean by an effects-based approach, right? So do we think about market effects in the sense that there is some form of evidence of outcome? It could be on higher prices, it could be lower innovation, it could be lower quality, something like, it's consequentialist in a way. Or is it, which is about the market, right? Mm-hmm. Or is it something that is a little bit broader in the sense that we're talking about exclusionary effects. So the idea that you're excluding, firms. I'm not getting into the discussion, these should be efficient, non-efficient, mm-hmm. etc. We'll come back. But what do you think about this? Is it really, what is a type of effects-based, what is a type of analysis? A market effects analysis? Is it like exclusionary effects one? What could be your perspective?
I think that you have to split the question into 2 probably. One thing is what would be covered by Article 1 or 2, and I think that if you look at the recent judgments, SEN, for example, but also Super League and the like, it's quite clear that the purpose of 1 or 2 is quite broad, I would say, and covering arguably both type of effects. But on the other hand, these draft guidelines are aiming at codifying the case law on exclusionary abuse of dominance, and therefore that is why there is a focus on exclusionary effects. Now, paragraph 6 of the draft is also quite clear that when we speak about exclusionary effects, we're not only looking very narrowly at the full-fledged exclusion of rivals. So in itself, this definition is broad, but I would be reluctant to say that this document covers more than exclusionary effects, not because we will not be in a position to run cases, but because there's been a strategic choice to focus this document on this type of effects. And by the way, if I may also go back to the point mentioned during the panel about exploitative abuses, of course, exploitative abuses are a core part of our enforcement action. We have ongoing exploitative abuses cases, so it's not at all the case that we're not interested. But the reality is that if you look at the type of document we're talking about, we had in the past 15 years something like 37, actually now 38 judgments on exclusionary conduct, and we just don't have that wealth of case law for exploitative abuses. Now, it doesn't mean that the Commission wouldn't take an interest in this area. It doesn't mean that the Commission wouldn't potentially come up with a different document dealing with these abuses. All these things, we're of course very happy to listen, but to me, the state of the law in these two areas is very different, and this has to be taken into account when thinking about policy.
But don't you think that, I mean, I'm thinking about the Apple case also, I mean, we have more and more this hybrid type of exclusionary/explorative type of cases. Mm-hmm. And wouldn't that be a good step for the Commission to, anticipating, I mean, that this could be a gap in the law to somehow come in and fill it in before, others do. So what's your perspective about this? I mean, at least have something on the exclusionary, explorative, hybrid type of category.
I hear you. On the other hand, one also has to be quite mindful of what kind of actions you want to take. I personally think that the guidance paper was something that made sense at the time because we wanted the case law to move in a certain direction. Then we have learned since then that perhaps some of the things that we had written in the guidance paper, perhaps because we didn't have all the experience in all the type of conduct that was described there, maybe we've learned that some of the things were not necessarily the right way to look at it. And so, there can be good things or bad things coming out when you decide to write down a policy document. I cannot speak on whether the Commission will in the future write a policy document on exploitative abuses, but I'm just saying that, of course, there's broader considerations apart from the fact that something is an area of interest for the Commission.
Coming back to this question about effects, some people, and we have the new Emile Zola of European competition law, the j'accuse type of category, raised the issue that the Commission is somehow abandoning the anti-competitive foreclosure doctrine in the guidelines. Do you agree with this criticism? And can you explain exactly, what is the difference between the competitive foreclosure, in case there is one, of the priority guidance and then the one in the guidelines? I mean, how does it look different?
I find this quite interesting. Indeed, there have been a couple of commentators who have taken issue with the fact that the draft guidelines do not refer to anti-competitive foreclosure. And I find it quite interesting because if you look at the case law of the past 15 years, even before the case law of the past 15 years, let's go back to the guidance paper. The guidance paper made a conscious choice to use the term anti-competitive foreclosure to refer to something else that was not necessarily the threshold for intervention under the case law. That was done again with the idea of trying to inject some more effect analysis in the case law. For good or bad reason, I'm not going to comment on that, but I think it makes sense if that was the situation at the time. Now, we know, 15 years later, that the case law has just not picked up that term. There are a couple of judgments from the General Court which refers to anti-competitive foreclosure mainly when quoting the guidance on enforcement priorities. So the Court of Justice, to my knowledge, has never used this term, and so personally I think that it would have been a mistake of law if we had used that term in the draft guidelines. Now, in practical terms, whether a word where you use the notion of anti-competitive foreclosure is necessarily very different from a word where you use the notions of competition on the merits plus exclusion, I'm not sure about whether the effects in practice would be very different in terms of the type of cases that we pursue. And because of that, I frankly find this a quite theoretical debate. I'm not sure really about the actual merits of this discussion.
Now, you mentioned before these three judgments that came the last few weeks, and one of the questions we had in the first panel also, we had some interesting discussions. How did the Commission feel about this case law? Is it like wind in the sails, kind of, yeah, we're doing right, let's move ahead with this? Or is somehow back to the drawing table, as some people have raised? What's your perception? And maybe discussing in case you like each of these cases, how do you think that will impact on your guidelines, draft guidelines?
Yes. So first of all, I was very much looking forward to these judgments because, of course, September has been quite a month in terms of developments of the Article 102 front. And from our side, of course, we were aware that these judgments were coming when we were preparing the guidelines, and we thought this makes sense because having the draft out there will give an opportunity to stakeholders to review those judgments when commenting on the draft. So this made a lot of sense. Now, if I read these three judgments, so Google Shopping from the Grand Chamber of the ECJ, Qualcomm predation, and Google AdSense, both from the General Court, I personally think that they confirm the fundamentals of the draft guidelines. I don't see any departure on the points of principle. If anything, actually, to some extent, they are even more definitive on certain points than the draft guidelines. Google Shopping is very clear, again, on the two limbs test, very clear on counterfactual. I think it fully supports the Commission position there. On the official competitive test, I find it very clear. It basically states that when it's relevant, we have to run it. Of course, for predation and margin squeeze, it is relevant and we will run it. Whereas in other cases where it is not relevant, we don't have to use it. Interestingly, it seems to put together the principle and the test, which is something that is not very far from what has been put in the draft guidelines. So from my personal point of view, I'm quite confident that the Google Shopping judgment is really in line with the draft guidelines. Doesn't mean that we won't have to change some parts of the guidelines here and there and adapt them and perhaps supplement some paragraphs. Of course not. This is something that we're looking at. And we will need to do this reflection in the coming months, also in light of the submissions to the public consultation. But I think that by and large, the judgment confirms the approach. When it comes to the other two cases, I'll be very brief here. Both AdSense and Qualcomm confirm the fact that there are presumptions on exclusive dealing on the one hand, and by extension on exclusivity rebates, even if that was already confirmed by Intel and Unilever, and on predation. Now, one could say that in predation, the judgment goes even further than the Commission. So certainly it states that there is a presumption for both the scenario of pricing below AVC and for the scenario of pricing between AVC and ATC with evidence of intent, which is something that we had put in the draft guidelines, and we're quite happy to see that the court takes the same position. But then it goes even further and states, for example, that coverage is not something that is necessarily relevant to rebut the presumption. One wonders whether the presumption can be rebutted at all on that ground, whether we are not more in naked restriction territory, in fact. And I think these are legitimate questions, but again, it's about the details. By and large, I think that the judgments really confirm the approach that we have outlined in the draft.
And it also be reported, talking about presumptions, that the Commission takes care not to refer to the concept of by object in the draft guidelines. I mean, you're using the concept of naked restriction. Some will say, and we had this discussion in the previous panel, that this is kind of a narrower category. So what's your view about this object effect distinction? I mean, we have the court mentioning that in Super League.
Yes.
And some people have also mentioned in the past. I mean, I remember Advocate General Colomer, for instance, he used that in the sci-fi case, if I remember well. But so why the Commission doesn't use that concept? Are you accepting what was previously mentioned, I think, by Simon, that, well, if you put it there, that would mean that everything else would be an effects analysis? Can you explain a bit the reasons why you are not bringing in this dichotomy, even if the court now embraces it a little bit?
Well, first of all, I found very interesting what Simon Holmes stated before about the naked restriction versus by object point. Of course, to my knowledge, is the first time in Super League that the ECJ used this term, whereas, and it was actually came in December last year. From my personal point of view, I understand why the court used that term, but I think that we have to be careful not to draw too many analogies between Article 101 and Article 102, because the text of Article 102 does not refer to by object, and by object in the Article 102 territory to me sounds something different than in 101, because in 101 by object means essentially that you don't look at effects at all, whereas if we start to import the term by object in Article 102, I wonder if we could say that it is an absolute presumption where you don't even look at effects, when, again, the text of the norm does not contain that kind of language. Then I'm also thinking that perhaps it could bring additional complications in terms of what to do in terms of distinction between the soft presumptions, how we call them, and hard presumptions. Are exclusivity rebates a by-object restriction? If they are, then it means that indeed the presumption can be rebutted. If they are not, how do we call those? So all in all, I think that we felt comfortable with using the term naked restrictions, being well understood that effectively we mean the same thing that the Court of Justice meant in their own judgment. We're not trying to come up with a novel concept. It's just, to me, really a terminology point rather than a point on the substance. How to call them rather than what to do substantively.
Although one might say that, by object restrictions you can usually come up, and this is something clear with generics, etc. In Article 101, you can come up with showing that there's no effects, though rebut somehow the qualification by object restriction. But you cannot do that for naked restrictions.
You would do it in order to rebut the qualification, not in order to say that there are no effects once you have established that it is a by object restriction.
What I'm saying, there is some distinction between by object and naked restriction from that perspective. I mean that
under Article 101 and Article 102, I would say so, and that is why I think that it could be potentially confusing to start to use the notion of by object in Article 102 cases. Then I'm sure that the court had their own good reasons, and I'm not saying that there was not a right term to use. I'm just saying that from our personal point of view, we thought that it would make more sense to stick to the more established term of naked restrictions. But again, we are here to listen, like for everything, and so if there was some feedback in this respect, of course it's something that we would be happy to take into account for the next steps.
But in by object is different in 101 and 102. I might venture to say, why not also by effects being different in 101 and 102, in the sense that in 101 you need, at least this is what the Commission has done in the guidelines, you need to prove market effects, while in 102 might be you don't need to go as far, in the context also that you are very much emphasizing that these effects are potential, likely, whatever, potential effects, basically somehow moving away from market effects to exclusionary effects. So maybe two different concepts of effects.
Yes,
between 102 and 102. How do you
I do agree that the test is different, also because you have shown that the company is dominant, there is a special responsibility that must mean something in the analysis. So I agree that the two notions do not entirely overlap.
So what is also interesting is that September was a very important date, not only for Article 102, but also because we had the publication of the Draghi report. And Draghi actually says a few things about competition law, and also somehow, without mentioning the guidelines, the draft guidelines, at least raises some issues with regards to some of the presumptions. I will not say that he's against the presumption, that's my interpretation of it, but eventually he's asking for more in terms of the conditions that trigger the presumption. I think he refers more to time. I just quote from his report. He says excessive discretion on the finding of exclusionary abuses is left by the draft guidelines. Also, he mentions guidelines. On the enforcement of Article 102, released in August 2024, as an example, time can be presumed to have exclusionary effects that the guidelines do not detail under which conditions, right? So, and then, he also mentions that there is no safe harbor for dominant firms setting prices above average total costs. Although we know that selective price cutting, you might have a problem also even if you are pricing above average total cost. How do you respond, to these criticisms of Draghi? How you take that into account? And in particular, because you have a footnote where you just explain the case law, you cite the case law, which in which the Commission is founding itself to have to say that there's a presumption for tying. However, this footnote doesn't explain what are the conditions that trigger. So it just cites the case law. So is it going back to the drawing table for this, or is it not really a valid criticism?
So first of all, I don't see it as a criticism. We are welcoming comments from everyone, of course, even more from Mario Draghi. So there is absolutely something that we really welcome. The two specific points that he mentions, and the general point about discretion, I think that has to be seen really in terms of what he means here. Some have said we need some safe harbors, for example, when establishing dominance. That's also a point about discretion, perhaps, and it's something that, of course, we can take into account. But then, I think more specifically, he's referring to these 2 points, and the first one is about tying. And look, the reality is that the case law, as recently as in Google Android, stated that there is such a thing as presumptively anti-competitive tying, and so we have to do a good job, we have to explain where this happens. We have tried to make it clear that for us this is the cases where the product at stake is such that basically leads to be used by the customer. For example, if you are delivered a box of nail cartridges in your warehouse, of course you're going to use it, you're not going to leave it there in the corner. But of course we can try to do better and try to be even clearer as regards which situation it is not necessary for the Commission to prove the effects of tying. Of course we're not talking about the Google Android and the Microsoft type of scenarios. That is clear. We're talking about something different. And on the point of above cost pricing, it is true that we left open the possibility exceptionally to find an abuse even in cases where there is above cost pricing. We refer to the container shipping cases, Compagnie Maritime Belge and the like. Those were very specific cases, very special circumstances, so we certainly didn't want to leave the door open to explain it that there is, and to prove it that there is an abuse every time that there is pricing above cost. That would be absurd. So we'll see what we have to do to address this point as well. So we take note and we reflect on these points.
I'm sure there are many questions from the floor, comments. We have a few minutes for that. Maybe people haven't intervened before. So yes, I mean you wanted. Sorry, there was a hand there, so it disappeared.
Simon?
Oh, Simon then, yeah.
I welcome the comment you made a moment ago about you need to be careful not to go too far in terms of the evidential burden. I'm slightly nervous of asking this question without rereading the entire guidelines, but is there scope, do you think, for the Commission to include in the guidelines something on where it's not necessary to provide detailed economic analysis? I'm thinking of very helpful comments in, for example, the Dutch draft guidelines on sustainability a couple of years ago. I also think back to the Commission's 2004 guidelines for exemptions, where there's some very helpful paragraphs on that. I know in your categories you talk about things like specific tangible points of analysis and evidence and so forth, but I don't think there's any explicit reference to the need or otherwise for quantitative analysis, and I think that would be a helpful steer.
So that's a comment that we're happy to take into account. At first sight, I would say that, of course, in general, we welcome both qualitative and quantitative data, but it's clear that to the extent that quantitative data becomes a quite refined type of exercise, that will become less relevant as we move up on the staircase, so to say, of type of abuses that we have identified in paragraph 60. So meaning for naked restrictions, normally there wouldn't be a need to engage on quantitative data.
I agree with what you're saying. It's just dealing with a perception that is out there wrongly, that you always have to have detailed economic analysis, which, as you say, and I would say, is not always the case.
Okay, we'll take note.
We have probably time for one more question or comment. Yes, Ulrich? Yeah.
I have a question regarding...
Maybe say who you are also.
William Miller, I'm from Rebalance Now, which is a young German anti-monopoly organization. I have a question. It came up a little bit earlier this morning, also the question about being are the guidelines future-proof enough, and especially when it comes to multi-sided markets or platform. I think there's a new power that resides with the owners of those platforms because they can simply exclude people, right? So how would you fit that into kind of the categories of different the different groups? I mean, would you say, okay, if a platform owner uses that power to exclude people from the platform just to coerce them into doing something that aligns with their business interest, where would that fit into those categories? Is there something that you could also see as naked restrictions in a way? Because, I mean, that is something I think, if so, maybe it should also be made more explicit in the guidelines, I think.
And to join a bit this, I mean, there's a perception that was also shared by some speakers in the previous panel that this is not that much about the future digital economy. Mm-hmm. We don't see anywhere the word ecosystem, for instance, or ecosystemic theories of harm. So there's nothing about digital types of theories of harm, apart from the usual ones that we already know. I mean, so is this something that you think my guidelines are there also to lead in a way, to show the way, or how do you feel the Commission could take that into account, that criticism into the account?
Yes, I think it's two different types of angle of perhaps the same question. So, of course, we have to work with the case law and with our decisional practice. This document is not the document to start to come up with new theories. For that, we have other types of instruments. We have cases, we have investigations, and I think that it's fair to say that we have a number of interesting cases in the pipeline, and we will see how those develop. But that is the instrument that we have to pursue competition issues in the current environment. This document is about reflecting the law. It doesn't mean, and the Commission practice, of course, it doesn't mean that, of course, we don't have to take into account the future-proof nature of the document, because it has to be able to stand the test of time. But as I mentioned before, first of all, let's not disregard the value of having for the first time a general test clearly spelled out, because that is the test that one would have to apply to abuses for which there is no case law. And it is very important because it's the first time that the Commission is putting that black on white. Second, when it comes to specific features of the digital economy, I think that we have said quite a bit. There is a whole section on dominance, where we explain in detail value network effects and the like. The self-preferencing part, of course, doesn't say that it's only about digital, but it's quite clear that that kind of abuse is more likely to take place in a digital environment. We are adopting the same test when it comes to the Google Ad Tech case, which is, of course, a fairly different case compared to Google Shopping. And a lot of the other practices, I think that one way or another, they keep on being recurrent also in the digital environment. So it is true, of course, that we don't have new and unexplored theories of harm in the document, but that has never been the purpose of the document. It's not that we're not interested or we're not daring, it's just that for that kind of, for those kind of theories, we rather look somewhere else. That being said, if there are any specific points that you think is worth exploring and on which would be helpful to have more guidance, we can definitely take that into account for the purposes of the final iteration of the document. So we are really happy to listen to what specific parts you think we should be exploring more.
Well, thank you very much, Max. It was very informative and interesting. So I will ask the speakers for the next panel to join here. Thanking Max, of course, for his participation.